This is legal passage. Start. There is no express provision as to the power of the Supreme Court to punish the contempt of the High Court or the subordinate courts. In India, before the Contempt of Courts Act 1926, the jurisdiction of the High Court in respect of the contempt of subordinate courts and inferior courts was regulated by the principles of common law of England. The High Courts, in the absence of statutory provision, exercised the power of contempt in respect of the subordinate courts on the premise of the inherent jurisdiction of a court of order. However, in a case, the Calcutta High Court expressed a contrary view and held that there was no such inherent jurisdiction with the High Court. This conflict with regard to the High Court's power to punish for the contempt of the subordinate courts was set at rest by the Contempt of Courts Act. Section 2 of the Act shall have and exercise the same jurisdiction, power, and authority in accordance with the same procedure and practice in respect of contempt of courts subordinate to them as they have and exercise in respect of contempt of court of themselves. However, no High Court shall take cognizance of a contempt alleged to have been committed in respect of a court subordinate to it, where such contempt is an offence punishable under the Indian Penal Code. A similar provision is found in the Contempt of Courts Acts and also in the existing Contempt of Courts Act. In England and India, the authorities are based on the basic foundation of inherent power of a court of record having jurisdiction to correct the judicial orders of subordinate courts. The King's Bench in England and High Courts in India, being superior courts of record and having judicial power to correct orders of subordinate courts, enjoyed the inherent power of contempt to protect the subordinate courts. The Supreme Court, being a court of record under Article 129 of the Constitution of India and having wide power of judicial supervision over all the courts in the country, must possess and exercise similar jurisdiction and power as to the High Courts had prior to contempt legislation. Inherent power of a superior court of records have remained unaffected even after codification of contempt law. Article 129 of the Constitution of India declares the Supreme Court a court of record, and it further provides that the Supreme Court shall have all the powers of such a court, including the power to punish for contempt of itself. The expression used in Article 129 is not restrictive, instead, it is extensive in nature. If the framers of the Constitution intended that the Supreme Court shall have power to punish for contempt of itself only, there was no necessity of inserting the expression including the power to punish for contempt of itself. The article confers power on the Supreme Court to punish for contempt of itself, and in addition it confers some additional power relating to contempt as would appear from the and widen the scope of powers. The plain language of Article 129 clearly indicates that this court, as a court of record, has power to punish for contempt of itself and also something else which could fall within the inherent jurisdiction of a court of record. In interpreting the Constitution, it is not permissible to adopt a construction which would render any expression superfluous or redundant. The courts ought not to accept any such construction. While construing Article 129, it is not permissible to ignore the significance and impact of the inclusive power conferred on the Supreme Court. Since the Supreme Court is designed by the Constitution as a court of record, and as the founding fathers were aware that a superior court of record has inherent power to indict a person for the contempt of itself as well as of courts inferior to it, the expression including was deliberately inserted in the article. Article 129 recognized the existing inherent power of a court of record in its full plenitude, including the power to punish for the contempt of inferior courts. If Article 129 is susceptible to two interpretations, we should prefer to accept the interpretation which would preserve the inherent jurisdiction of this court being the superior court of record to safeguard and protect the subordinate judiciary, which forms the very backbone of administration of justice. The subordinate courts administer justice at the grassroots level. Their protection is necessary to preserve the confidence of people in the efficacy of courts and to ensure flow of justice at its base level. The High Court, being a court of record, has inherent power in respect of contempt of itself as well as its subordinate courts, even in the absence of any expression provision in any act. The contention that High Court has power of superintendence over the subordinate courts under Article 227 of the Constitution. Therefore, High Court has power to punish for the contempt of subordinate courts, and since the Supreme Court has no supervisory jurisdiction over the High Court or other subordinate courts, it does not possess powers which the High Courts have under Article 215 is misconceived. Article 227 confers a supervisory jurisdiction on the High Court, and in exercise of that power the High Court may correct judicial orders of subordinate courts. In addition to that, the High Court has administrative control over the subordinate courts. The Supreme Court's power to correct judicial orders of the subordinate courts under Article 136 is much wider and more effective than that contained under Article 227. Absence of administrative power of superintendence over the High Court and subordinate courts does not affect the Supreme Court's wide power of judicial superintendence of all courts in India. Once there is the power of judicial superintendence, all the courts whose orders are amenable to correction by the Supreme Court would be subordinate courts, and therefore the Supreme Court also possesses similar inherent power as the High Court of the under Article 215 of the Constitution of India with regard to the contempt of subordinate courts. The jurisdiction and power of superior courts of record to punish contempt of subordinate courts was not founded on the court's administrative power. Instead, the inherent jurisdiction was conceded to superior court of record on the premise of its judicial power to correct the errors of subordinate courts.